Good morning, ladies and gentlemen, and once again we'd like to welcome you to the 5th edition of our webinar. We are so happy to have you online, wherever you are, all over the world, home or abroad, all over the world. Welcome to First Registrars and Investor Services Nigeria, First Registrars and Investor Services Limited. Thank you so much for honoring us with your presence on this special occasion. With me this morning are the Chief Magistrate of Lagos High Court, Head of Probate, Mr. Patrick Nwaka, and then we also have Mr. Barrister Aaron Olaoye, Head of Head of Probate, First Registrars and Investor Services Limited. Welcome to this wonderful webinar. Viewers, we are sure you are going to have a wonderful time today, and please don't hold back with questions that you have after the presentation by our guest speaker. Thank you so much for honoring us with your presence this morning, Chief Magistrate. Now, going on to our topic shortly. Before then, I would like to just quickly take the profile of our guest speaker, the Chief Magistrate Patrick Emopute Nwaka. He serves with the Lagos State Judiciary and is the Chief Magistrate, Administration and current Head of Department Probate Section of the Ikeja Judicial Division of the High Court of Lagos State. Mr. Nwaka graduated with honors from Edo State University, Epoma in Edo State in 1998 with a Bachelor of Laws degree and attended the Nigerian Law School Buhari in Abuja in October 1999. He was thereafter called to the Nigerian Bar in January 2001. He later had a brief work stint with the law firm of Prince A.N. Onyibuchi and Company in Benin City, Edo State, from where he later proceeded on national service, the NYSC National Youth Service, from May 2001 to May 2002. Thereafter, he was posted to the law firm of Messrs. Abumchukwu Okoye and Company in Lagos as his place of primary assignment. Upon completion of his National Youth Service, he worked with Messrs. Morayo Lebi and Company and Messrs. Ezim, Chris and Associates, both based in Lagos State, before his appointment as Magistrate Grade 2 on July 1, 2004. Mr. Nwaka has over 21 years of cognate experience in the magistracy of Lagos State Judiciary, having served in the magistrates' courts spanning various magisterial districts such as Iboshere, Apapa, Ikeja, and Yaba magistrates districts. He has vast experiences in family matters pertaining to children's rights and ancillary matters. He has worked with the Lagos State Special Offences Mobile Courts, Alausa, at Bola de Oshodi, and the Family Court in Ikeja and Yaba magisterial districts. Apart from having presided over tenancy, civil and criminal matters in various magistrate courts at the aforementioned districts, he has served twice as a member of the 2006 and 2014 Magistrates Association of Nigeria National Convention local organizing committees, when Lagos State Judiciary hosted the National Convention of the Magistrates Association of Nigeria in 2006 and 2014 respectively. Mr. Nwaka is happily married with children. Today, sir, he will be sharing very, very invaluable insights on our topic, drawing from his extensive work experience in legal and probate matters. It gives me great pleasure to once again welcome the Chief Magistrate, Mr. Patrick Emupute Nwaka. Welcome, sir. You're welcome, sir. So, without further ado, we would like you to just give us a rundown on probate administration in Lagos State. What is probate, and what is probate administration? What are the processes involved, and how can people who are interested or who have issues relating to probate matters, approach them effortlessly?
Where the estate will go with the bank certificate to banks and other institutions where the estator had monies, stocks or shares to profile, to get the profile of the assets, monetary assets and stocks of the deceased person. In the process, other documentation will take place, and leading us to the eventual issuance of the grant of probate. That is where there's a seamless process without issues. Sometimes there could be issues in the sense that some beneficiaries of the estate may dispute the contents of the will and want to challenge that. They could do so by filing caveats or going straight to court to challenge the validity of the will. Now, for letters of administration, these are instances where deceased persons died without having written wills. In such cases, certain members of the estate, that is beneficiaries of the estate of the deceased person, would approach us by way of a written application informing us of their intention to apply to be appointed as administrators to manage the estate of the deceased person. Unlike in case of a will, where the testator would have named the persons to manage their assets after their death, those are known as executors. in the case of letters of administration, the beneficiaries among themselves would approach us to indicate that a number of them have been nominated perhaps by the estate to manage the estate, and then we'll go on to process the application in the form of issuing bank documentations that they will go on to procure and process, like bank certificates, which they would, like I said, which they would take to determine the financial profile and stock profile of the deceased person and revert to us. But in this case, because it's a situation whereby the deceased person did not name the administrators or to manage the estates, it's not as straightforward as when they apply for grants of probate, and we need to take steps to ensure that the persons who are applying as administrators are those who are bona fide to so apply. So certain measures are put in place to ensure that we do not deal with fraudsters. So such as we have to they have to apply for a newspaper publication, which is similar to in church what you call banns of marriage, where they will notify via newspaper publications the whole world that certain persons are applying to manage the estate of deceased persons, and then any person or group of persons who may be objecting to such application have a time frame within which to contact the probate registry and lodge their objection to such an application. Usually, where there is no objection, after 21 working days of the publication, we go ahead to do. Before then, apart from the newspaper publication, another safeguard we take is to get the applicants who are applying for letters of administration would provide sureties who would stand like in form of guarantors to ensure that if at the end of the day it is shown that the persons who have applied for letters of administration ought not to, they would indemnify the estate by refunding whatever monies may have been dissipated by those who ought not to have applied for the application. At the end of the day, when all this paperwork has been completed, we'll go ahead and issue the letters of administration and grant of probate. That's basically, in summary, what it entails to obtain grants of probate and letters of administration in Lagos State. Thank you.
Thank you so much, sir, for that brief introduction into probate, into the probate process. Now, there are instances where, you know, we have various people coming up with various letters of administration issued for the same estates. And as registrars, we have challenges with identifying who the actual bona fide beneficiaries should be when we receive these different letters of administration purportedly from the same family members for the same estate.
Yes.
And you know, maybe in a situation where a man marries a couple of women, and you know, one arm of the family gets an LA, the other arm of the family gets an LA, and they are all after the same estate. So how do you manage this kind of challenge in the probate registry?
Thank you for this question. Before now, when our processes were partially automated, when we were still doing manual processing, basically, we tended to have this challenge because it was, for instance, Ikeja probates, we have been dealing with applications as far back as 1860. So a lot of times people would have made application, one set of the beneficiaries would have applied, and the other set, another set would apply for the same estate. But because we didn't have, because of the paperwork that was in place at the point in time, it was difficult to trace those estates. But now, thankfully, we have a procedure in place that where someone comes to apply for letters of administration in respect of the same estate, where there's an existing application and the same estate is being processed, there will be there's an indicator that will flag and show that there's an existing application in respect of the same estate, and as such it would not be in a position to proceed with such applications. We've had one or two instances in recent times where a deceased person, the widow, applied for letters of administration with her younger brother. She appeared not to have carried along the late husband's siblings because they had no children in the marriage.
Wow.
So later on, the man's siblings on their own approached us to apply for letters of admission in terms of the same estate. As soon as the estate was entered, it was flagged off, and they got to know that there's an already existing application in respect of that estate. So that is one of the ways in which we check such dual or multiple applications for such estates. For other cases where these things arose when we're still operating manually, the best resort is the parties would have to go to the probate courts before a probate judge, and then the court would, after hearing parties, set aside one of the applications. That is where the parties are unable to agree. But where parties are able to agree, we could consolidate both applications and then go on to process same. But in cases where where the two applications, where two grants have been issued, it is the courts of law that the parties would approach to have one of the, because in law the first application in time prevails. So the court will now set aside the second grant of probate, because they cannot, in law, there cannot be two grants of probate in respect of the same estate anywhere in the world. It is impossible.
Okay, thank you so much, sir. Now, maybe you want to make further presentation on the subject, sir.
Yes. Thank you for having me here as a guest speaker in respect of the 5th series of your webinar on the topic overcoming bottlenecks in the probate and letters of administration process in Nigeria. Now, my approach to handling this topic is twofold. Firstly, to identify common bottlenecks that stall the seamless process of obtaining grants of probate and letters of administration in Lagos State. And second is to offer practical tips that could stem such ugly tide in the future. Now, I will proceed to do justice to my paper. The Managing Director, Chief Executive Officer, First Registrars and Investor Services Limited, the Chief Operating Officer, First Registrars and Investor Services Limited, all the management staff of First Registrars and Investor Services Limited, all the divisional heads, the head corporate, secretarial and probate services, the head probate and estate administration, all the departmental heads, men and women of probate strategic business units of First Registrars and Investor Services Limited. Ladies and gentlemen, I want to express my appreciation to the entire First Registrars and Investor Services Limited family for inviting me as a guest speaker at this webinar with the topic overcoming bottlenecks in the probate and letters of administration process in Nigeria. I intend to address this very apposite topic from the standpoint of my experience of the workings of the probate registry Ikeja in the High Court of Lagos State. Now, the term bottleneck simply means the part of a process that is too slow or cumbersome. And I will proceed to give about 7 bottlenecks from my experience that store the smooth and seamless process of applying for grants of probate and letters of administration in Lagos State. And these are the bottlenecks. First one is litigation and beneficiaries disputes. Now, this particular one applies mainly in cases where there are the where the deceased person died testate or wrote a will. Now, you find out that sometimes when the wills are read, certain beneficiaries are dissatisfied with the provisions made in the will, and they go on to challenge the validity of the will on grounds as of a lack of testamentary capacity. The argument that the testator or testatrix did not have the mental capacity to write a will, or they could challenge it on grounds of undue influence, arguing that the testator or testatrix was unduly influenced in making the testamentary dispositions in the will. Now, they could also do so by way of filing caveats to the application in process of applying for grants of probate, where they find out that there's an application, they could lodge caveats. Caveats, in a sense, is an objection to the process. And once they file a caveat, we at the probate registry, we stay action. We don't take any step until the issues arising from the caveats are addressed. And there are two ways these issues can be addressed: by way of in-house mediation, in the sense that some of the beneficiaries could approach us to call for a mediation, where we call the parties to a round table, they discuss their differences, and if we can get them to willfully and amicably resolve their differences, the caveat is then lifted, and then we go ahead to process and conclude the processing of the grants of probate. In some cases where they are unable to agree, we advise them to seek litigation, to go to court, for the court to resolve those disputes. Now, the second bottleneck we often encounter is difficulty in tracing some assets and valuation issues. Now, this arises where persons who have died have vast estates, maybe spread in several jurisdictions, some outside Lagos State, some outside Nigeria, and maybe these assets are not adequately captured in their will. And in the course of processing the letters of administration or grants of probate, issues arise. We know that Daddy left one house in Ijebu-Ode, Daddy has one house in England, Daddy has a house in Switzerland. When they are not captured, the estate would have to take steps to trace these assets to capture them in the application for grants of probate or letter of administration, and these things stall the process. Another bottleneck we normally encounter is incomplete and incorrect documentation. Now, this arises sometimes where you find that estates, particularly with letters of administration, where the applicants are inexperienced in the process, or they do not engage solicitors who are well versed in the process to go ahead and process the application. Now, certain times they find out that they do incomplete documentation. Sometimes even when we give them documentation to process, such as bank certificates, they delay in returning these certificates, these documents, and until these documents are returned to us, we cannot proceed with the application. These things also constitute delays in the process. Another bottleneck we encounter is delays in presenting sureties in cases of a letter of administration, because, like I said, sureties are like guarantors. Because we do not know because we at the probate registry cannot determine whether the applicants for letters of administration are the bona fide beneficiaries who are applying. We need to take certain steps to guard against fraudulent applications. That's why we ask for them to present sureties who will stand as guarantors to ensure that those guarantors will bear the cost of any estate that is dissipated in the event that it is found that those applicants are not bona fide beneficiaries of the estates. Another bottleneck we encounter, which is very common, is one I refer to as courts and administrative delays in the probate registry. Now, this one has to do with bureaucracy. Now, even when they go to courts, thankfully in Lagos State now, the authorities are embarking on automation of the courts. So the litigation in courts, at times when they are in courts, you hear cases of files are missing, and for the probate registry, there are so many, lots of bureaucracies in the process. Sometimes you find that in the process they will tell you some instances of the probate file is missing. For instance, in the Kenya now, we deal with files as far as 1860 something. So tracing some of those files manually, because we still do them manually. We're in the process of digitizing our archives, and when that is completed, at the touch of a button, at the click of a button, you can access every file, and that would eliminate this very worrisome bottleneck of courts and administrative delays. Then another bottleneck is the one I refer to as executor inefficiency, inaction, or experience. Yesterday, there was a counsel, a lawyer that came to meet us. Now, the challenge she's having with the estate, this is an estate where the owner or the testator died and wrote a will. But the challenge is that one of the administrators is unwilling to come and do the needful. So she came to us for advice on what they could do to address the situation. Now, for reasons best known to such an executor, if such an executor is unwilling to carry out the instruction of the testator, the best thing for such an executor to do is to come and renounce his or her appointment and say, I'm not willing to act as an executor. I'm not willing to act as an executor. But until that is done, the only other option is for the estate to go to court to obtain judicial order removing such an executor. Now, you also have cases where the executor appointed is inexperienced in probate matters, and that experience can be a very, very costly matter in the course of the process, unless such executors seek professional, competent advice to guide them in the process. Now, the last of the common bottlenecks I refer to is missing or hard to locate beneficiaries. Sometimes we find that certain testators or deceased persons have several children, maybe up to 40 children. Some are based all over the world. There was a case I was doing recently where such an issue arose in courts before I got to the probate. Now, one of the man's children by another wife is said to be based in Cote d'Ivoire, but they couldn't trace the person. The contact information of this child or this beneficiary was not reliable. So in such cases where it's difficult to trace certain beneficiaries, that could also stall the process, particularly where such beneficiary is a key member of the estate and needs to make input in the application for grant of probate or letters of administration. So these are some of the bottlenecks that we have come to experience in the course of our engagements with users of the probate registry. And I will go ahead to offer some practical tips that could help in mitigating such circumstances in future. Number one, it is important for those who wish to write wills to prepare up-to-date wills, which clearly specify what and what, that is bequest, what and what they are giving to each beneficiary. And also in the same way to appoint trusted and competent executors to manage the estates. This will help to a long way to prevent confusion, particularly where we're dealing with complex estates, and it could minimize the risk of contesting such wills through litigation and caveats. Now, it's also important that where persons choose to write will, regular updates of such wills are advisable to ensure that they reflect the testator's current wishes and circumstances. Another possible tip I'm recommending is for owners of property to maintain organized and accessible records of their estates in their lifetime, so that when they depart, it will be easy to collate the entire assets in the course of applying for grants of probate and letters of administration. That would facilitate the speedy and proper management and distribution of assets by executors and administrators upon the demise of the owners. The third tip I'm suggesting is prompt solicitation of professional advice. In this one, this is a tip. I'm suggesting that engaging qualified and credible solicitors who are well versed in the probate process is similar to the saying that is teaching time saves 9, and as such competent hands would, in the course of processing the applications, easily anticipate possible challenges, nip those challenges in the bud, while ensuring that all legal and procedural requirements are promptly and efficiently met. Another tip I'm recommending is the introduction of proactive, sustainable administrative procedures by the relevant official authorities to address courts and administrative delays. One such recommendation is the full automation of the courts and the entire public registry, as well as provision of complementary infrastructure such as constant electricity supply, internet services, to ensure that some of these bureaucratic delays are removed in the process. Another suggestion I'm making under this head is that they should institute formal complaint channels to enable the certified users of the probate registry and courts to channel their complaints along with prompt disciplinary action upon proof of such bureaucracy and other indiscretion by staff of court and probate registry. We know in the process corruption is quite rampant in the process. Now, by the time we set up this, by the time the courts and the probate registries are fully automated, a lot of this bureaucracy, like instances of missing files, officers sitting on files until they are financially induced to do their duty, would be largely eliminated. Then we could also advise, though it's not very common here, we could also advise owners of assets to consider the option of setting up what they call living trusts. Now, living trusts are a vehicle whereby someone who owns property in his lifetime can, in such living trusts, specify, I want to give so and so and so and so to A, B, and C. And this is done in the person's lifetime, so that upon death, there won't be issues about transfer of assets from the owners or from the grantor to the beneficiaries. These are some of the suggestions I'm preferring that would, in the long run, assist in mitigating the bottlenecks that users unfortunately go through from time to time in the application for probate, grant of probate and letters of registration. Thank you very much.
Thank you so much, sir. That was very robust and quite enlightening. On this note, we also want to look at it from the perspective of the registrars, because our work as registrars is intertwined with the work of the probate registry. Yes. And when one aspect of the job is completed, another aspect of the job starts at our own end. You know, so Barrister Adeoye, would you like to run us through the transmission process, you know, from the registrar's point of view? I know that once beneficiaries or executors obtain letters of administration or grant of probate from the probate registry, usually they will then go to wherever the assets of the deceased are located, you know, to process transmission into the beneficiary's name. So just quickly, very briefly, run us through what the registrars expect from beneficiaries or administrators, you know, to estates, so that then we can now tie it up with, you know, the bottlenecks and how to resolve, to have you know, a robust way of advising our viewers on how to access their beneficiaries' estates.
All right, thank you, moderator, and thank you, our asset of disease to the estate of the disease. Among these requirements are the letter of administration so issued by the courts, by the High Court. The letter of administration is number one or primary requirement for the transmission, and we also request for the death certificate of the disease. We also request for the banker's confirmation or signature of the administrators or the executors, as the case may be. That will be gotten from the estate of the estate. Of course, we expect the estate to have opened an account with the bank, and from the bank, then the bank will issue the banker's confirmation of the signature of the executors or the administrators to the estate. We also request for complete a request letter. We also make a request that they should give us a letter, and in some cases we have a form which suffices. The executors or administrators, as the case may be, we fill that form, and that suffices for the request letter. And we ask also for valid means of identification of the executors or the administrators, as the case may be. And in most cases, we also ask for the presence of the executors or the administrators, as the case may be, because we also want to determine that the people that presented themselves as the administrators are the administrators. We actually want to see them to ask one or two questions to determine the validity of their claims. And yes, if a little amount is paid for transmission, that will be done in our office here and all that. So upon the provision of all these, we carry out transmission on the estate. And after the transmission of the estate, then the disease representative can have access to the dividends and every other thing that the disease has with first registrars. All right, that is the process. And in the same vein, I also want to mention one or two bottlenecks that we also have as first registrars. Yes, towards the probate processes. Yes, the bottlenecks are two. One, from the representative of the estates, and two, from first registrars processes and procedures. Yes. First, from the personal representative of the disease, which are the executors or the administrators of the case. A lot of time we discover that all these requirements, 5 in numbers, a lot of time we see that partial documentation are made here. Some requirements are not presented, so we will have to wait until those documents are complete. For instance, we have seen cases where the administrators or executors, as the case may be, will come here with maybe 2 or 3 of the 5 requirements. So we will have to wait until the documents are complete. Yes, the second thing to note is that we discovered that some of the time they present the documents and the necessary fee to be paid for transmission, they will defer that. For a long time, they may not pay that, and we may not be able to start the process until such amount is paid. Then number 3, we discovered that there can be contention. So number 3, we discovered that there can be contention between the families. We have observed that quite a number of times the families who come here to argue and say, oh no, the person that is on the letter of administration is not the right person to be there and all that. So that contention will affect our processes here. In most cases, we see if we can handle that in-house, and if not, we refer, such case to the court. Then number 4 again, we observe that the letter of administration presented to us some of the time do not include the shares that the disease has that is domiciled with us is not listed in the letter of administration. So with that, we might not be able to process. So we will have to request that the letter of administration be amended. So with that, the time for the amendment and all will create a delay in our process. So these are well, let me take it again. Yes, for first registrars, there are some requirements that will help us do what is called transmission, moving the asset of the deceased to his estate. Among them is letter of administration. The letter of administration is granted by the High Court, and without the letter of administration, we might not be able to do what we call transmission. And so once we get the letter of administration and other requirement, we process transmission. Secondly, we request for death certificate of the disease, because a lot of time we have seen that the death certificate in most cases are not obtained from National Population Commission. Some of the time we discover that the death certificate is procured from a private hospital and all that. But we always advise that such certificates will be from National Population Commission. Number 3 is banker's confirmation of signature. We always request that banker's confirmation of signature should be obtained from the estate or the bank where the estate accounts is domiciled. So we request for that. We want to have the signature and the picture of the administrators or the executors, as the case may be. So we also request for letter from the executors or letter from the administrator requesting us to carry out transmission on the estate. We also ask for valid means of identification of the administrators or executors, as the case may be. So the valid means can be driver's license, can be voter's card of the executors or the administrators. We also request in most cases that the executors or administrators should be present, so that we should be able to get some information from them to determine the genuineness of their claims. We also ask for newspaper publication, especially where the deceased died intestate. We ask for newspaper publication. As the speaker rightly said, it will be displayed for 21 days. So the newspaper publication is part of the supporting document that will help us to carry out the transmission. So having said that, we also have some bottlenecks that we observe in our processes here, and the bottlenecks are in 2 folds. One, from the executors or from the administrators or executors, as the case may be, and the other is from the first registrar processes, which of course we have addressed. Well, from the executors or the administrators, a lot of time we discover that the required documents are not presented to us complete. Quite a number of times we observe that partial documents are presented for the transmission request, and where we don't have complete document, the letter of administration, the death certificate, the newspaper publication, and the rest, we might not be able to carry out transmission properly. Then, secondly, we observe that there can be dispute between families. Yes, a lot of times we see factions of families come here to debate, to argue, to contest, the letter of administration and the rest. So that a lot of time delay the transmission process. Of course, most of the time we find a way to resolve it here, and if not, we also advise them to take the matter to the court. Then another bottleneck we observe is partial letter of administration. Yes, letter of administration. We observe that partial informations are in the letter of administration. With the letter of administration do not carry the complete information required for transmission. For an instance, we observe that the shares that is domiciled with us in most cases are not listed on the letter of administration, and this to a large extent will delay the process, because we might be asking for an amendment on the letter of administration, and that will be done by the courts. So these are bottlenecks that we observe, that of course this is traceable to the administrators or executors, as the case may be. Yeah, from our own hand, we observe some bottlenecks also. And one of them is the delay in confirmation of letter of administration. Yes, for a long time we've been battling with this, and thank God our honorable speaker is here. So we observe that a lot of time, once we process letter of administration to the issuing court for reconfirmation, some of the times 2 months, 3 months, we do not get the letter of confirmation from the court, and this has been a major bottleneck as far as FRIS registrar is concerned, and I'm sure our honorable speaker will speak to that. The delay in confirmation of bankers' confirmation. Yes, when bankers' confirmation is submitted to us in FRIS registrars, we also request the issuing bank to reconfirm the banker's confirmation, and that is the normal procedure. A lot of time we observe that the banks delay in sending reconfirmation of the letter so issued by them to us, and to mitigate that, we'll be speaking with the banks, and obviously we've started seeing some changes from some few banks, and we are still expecting perfect change, of course, with some other banks that we are dealing with. Yes. So these are the challenges and bottlenecks, that we observe from our part as FRIS registrars, and majorly, I'm very sure that at the end of this webinar, our speaker will speak to the part that affects that concerns the High Court, while we move forward in our transmission process. Thank you, moderator. Yeah.
So, sir,
Yes.
in view of the current technological advancement, period that we now live in, we know that technology has overtaken a lot of things, and any company or any business that does not take interest in making technological changes, or in improving its technological process, technological aspect of his work, will lag behind in terms of service delivery. What is the Lagos High Court, or what is the Lagos Judiciary doing about ensuring that I know you mentioned in the course of the discussion that you are trying to digitize and move on to a complete technological platform for all your processes, but isn't the process taking too long? Isn't it too slow? What are you doing at the Lagos State Judiciary to ensure that the process is faster, more efficient, and that you can give better service delivery to your customers? Because take it or leave it, we are your customers. Everyone out there that has one business or the other to do with you will want to come there with and have the least hassle about before he or she gets service from you.
Yes.
So what are you doing to ensure that your technology is improved and that you deliver efficient and effective service to your customers?
Thank you for the questions from Mr. With regard to the issues, the bottlenecks that the first registrars and the investment services encounter in their interface, because of the interface with us at the probate registry. Now, with regards to, I'll take them one after the other. With regards to confirmation of letters of administration, I do admit that there are drawbacks in terms of delay in such confirmation. And like my paper earlier addressed, we are working, the major challenge has to do with the fact that our files, our probate files, we have a very large expanse of probate files in the KJ registry, and as at the moment we do manual tracing of the files to address applications for confirmation of the validity of letters of administration issued by the probate registry. Now, like I said earlier on, because of the vast expanse of files we'll be treating, some far back as the 1860s,
Wow.
it's often cumbersome because we have our staff at the archives units. We have to go and manually trace these files, and then these things take time. Now, to address that one, the Honorable Chief Judge of Lagos State is in the course of authorizing the full digitization of the probate registry, the archives. What this entails is that they will upload the contents of every probate file and store it in the cloud, so that at the touch of a button one can trace files. It's quite cumbersome because of the vast volumes of files that we have. For us in Ikeja, files that were filed recently, as recent as 2010 downwards, once those files have already been captured, so it's easier to trace those files. But the earlier ones, they are inputting them into trying to upload the content of those files, and I won't lie to you, it's quite a mammoth project, and we are hopeful that in the shortest possible time all our files will be uploaded and captured online, so that we will do away with the issue of manual tracking of files manually, but will now do so electronically, and that will also reduce the bureaucracy that it entails. With regard to the question about the probate registries adopting technology to enhance service delivery, like I said earlier on, we have the Honorable CJ is engaging with our consultants on how to fully digitize, because the major challenge has to do with the manual sourcing of files at our archive units. Now, once these files are, the other units are being captured, like having to do with when you apply, but the major one that is the key issue now is the archive units, that we're in the process of uploading the files into the system electronically, and once that is done, you will see a lot of improvements in our service delivery. We are working on that now, and I can assure you that as soon as that is done, you will attest to improvement in our service delivery. Thank you.
Thank you so much for that answer. Further, what are some of the recent changes in legislation regarding the probate processes in Nigeria? Are there new legislations that the public should be aware of? And what's the implication for people out there who have probate issues that need to be taken care of?
We have, at our own end, compiled a number of legislation, because to a large extent, legislations are what govern our processes. We cannot just on our own go on and take certain steps, because all our steps are guided by law. So there are certain legislations that we have made inputs to the Lagos State House of Assembly for them to tweak and update them in line with current realities. So also ensure that it would facilitate our seamless rendering of service delivery to the public. For instance, something that has to do with the publication, the fees for publication and ancillary matters. That is, we are working on that with the House to ensure that they graciously approve our request for an amendment of the relevant laws, so that this would also streamline our enhanced to the satisfaction of our customers and end users. Thank you.
All right. So recently at our end we had a challenge regarding jurisdiction of issuance of probate letters and letters of administration.
Yes.
To the best of our knowledge, we understood then that it's only the High Court that has the power to issue letters of administration
Certainly.
and probate letters.
Certainly.
But over time, we have observed that some individuals bring probate letters and letters of administration from courts that are not high courts, from different parts of the country. Isn't there a standard, or isn't there, how do we put it now? Is there not, does the judiciary not have the same level of regulation or law for the issuance of probates and letters of administration? Where an individual can bring the same document, and we know that this document is coming from the right source. Barrister Adeoye will testify that sometimes we get LAs from High Court, other times we get from customary court. Is there any law that permits a customary court to issue LA or letters or probate letters? So that at least we need the public needs to be educated about this, so that we don't have them spending time and money to obtain these documents, bringing them to the registrars, and then having the registrars turn them back that we don't accept these documents from customary courts.
Procedure rules of various states, and to that extent, it is the high courts that have jurisdiction to issue grants of probates and letters of administration. But you see, sometimes with regard to probates and LAs issued by customary courts, there's this certain confusion. Some people would approach these courts with the mindset that these properties are governed under customary law, and such customary courts would now, in my respectful view, erroneously delve into such matters and start issuing grants of letters of administration and probate, which raise issues over time. For, like I said, for me, the appropriate authority that issues such is the High Court, because it is under the rules of court, it is the High Court's civil procedure rules that make specific provisions regarding grants of probate and letters of administration. The confusion has to do with when people come and say this property is a customary property. Maybe our grandfathers got this and we inherited it under customary law. So customary courts tend to erroneously assume jurisdiction because those assets are tagged as customary, as assets that derive from custom of a people from a particular place. But I do not think that they have jurisdiction. It's a concern because a few times they approach us with in Lagos State. Thankfully, in Lagos State, no customary court in Lagos State issues such. We don't have these issues from other jurisdictions,
Wow.
and they want to come and this is what I'm looking for now. They want to come and reseal such grants in Lagos State, but it's difficult because the courts that purportedly issue such grants do not enjoy coordinate jurisdiction with the High Court, and so we are unable to accede to such requests in such instances.
So what is the judiciary doing about to address this situation? I mean, there should be a form of congruence. Being it's a system, the judicial system
Yes.
should be such that all the jurisdictions know what level their authority, where their authority extends to, and no
Yes.
further. We the public expect that the customary court should know, oh, these are what we have jurisdiction over. The same thing with the High Court. You know, of course, we know that the Supreme Court is the ultimate authority
Yes.
over all
Yes.
judicial
Yes.
matters in the country. But
Yes.
where the judiciary at its various levels are having issues of identifying their roles, their responsibilities, and what they are authorized to accede to or assent to or
Yes.
issue.
Yes.
Isn't that going to create a problem for the end users, who are the public like us,
Yes.
who eventually would have expended time and money and energy to obtain these documents, only to be turned back? Because I am concerned about the problem. It's a point of concern for us as registrars.
Yes.
The customer eventually begins to look at us as if we are being difficult.
Yes.
We don't have a right to reject what they are bringing. So
Yes.
what is the judiciary as a body doing to address this issue?
I would want to believe that the body of chief judges of various states would address this issue, because one ignorance that seems to lead to such circumstance is where people come and say, this this land is a customary, is governed by customary, by our native law and custom, and as such and then the customary courts now assume, wrongfully in my opinion, assume jurisdiction to go and issue grants that you don't have. Now I will give you instance using Lagos State as an example. Now in the hierarchy of courts, we know that the lowest court is the customary courts, followed by the magistrate courts, and then the high courts in Lagos State, before you have the appellate courts, Court of Appeal, and Supreme Court. Now the bottom line is it is the rules, it is the law establishing such courts that need to be looked into, in my opinion, because a magistrate court exercises appellate jurisdiction over customary court in Lagos State. And for example, in the under the magistrate court law, section 28 subsection 7 of the magistrate court law of Lagos State, it is specifically stated there that a magistrate court does not have jurisdiction to do anything that has to do with title to land.
Oh.
It's spelled out there.
Wow.
So if a magistrate court has been clearly designated as a court lacking jurisdiction to do anything that has to do with title to land, then how can a customary court in Lagos State assume jurisdiction to grant probate over customary land supposedly in Lagos State? So the important thing is that a lot of these courts ought to, when people approach them, particularly customary courts for customary grants of probate and earlies, they should look at the laws establishing such courts. I doubt if such laws confer jurisdiction in respect of probate matters to customary courts. So, in my respectful view, it appears a lot of those courts may have been assuming jurisdiction in those matters in error.
Wow. So as the chief magistrate of a probate registry here in Lagos,
Yes.
what would be your advice to registrars regarding this issue? Would we be right in rejecting LAs and probate letters that are issued by customary courts?
Yes, in my respectful view, yes. Because if you look at, aside from the laws creating respective courts, the customary courts, magistrate courts, the high courts, the Constitution of Nigeria, which is the supreme law of the land, has stated clearly that the high courts has unlimited jurisdiction. When the law confers unlimited jurisdiction on a court, it means the court has the powers, except for cases, there are certain cases that the High Court of a state do not have jurisdiction to determine, like those cases listed under section 251 that has to deal with the federal high courts, and the cases that have to do with employment related matters that go to national and industrial courts. Apart from these two classes of matters, the high court has unlimited jurisdiction in other matters which include land. So once as the constitution, which is the supreme law, has accorded the high court of a state unlimited jurisdiction, then how can a lower court as like a customary court now assume jurisdiction to grant probate in matters that they do not clearly have jurisdiction over? So a lot of times beneficiaries will come with the mindset that we got these letters of administration from the customary court, it is valid. But it is important, it's imperative, maybe they need to be enlightened that in law there's a maxim in law that says nemo dat quod non habet. You cannot give what you don't have. It is, if a court is not empowered by the law creating it to grant probate, then why should it assume a jurisdiction that it doesn't have? So there's a lot of awareness that needs to be done by all stakeholders to inform beneficiaries that it is in their best interest, even if the land is supposedly a land that comes under customary law, it is still the high court
That
that has jurisdiction to issue grants of probate.
So, just as a follow-up to that, I would want to throw this back to
Yes.
to your
Domain.
domain. What do you think the judiciary, I mean the enlightenment and the publicity and the education of what to do, where to go, should originally be the responsibility of the judiciary itself? What is the judiciary doing to enlighten the public about these matters? Because as long as we are human, people will continue to be born, people will continue to die.
Yes,
And
yes.
these are things that we cannot run away from.
Yes.
And the more the public is educated about these matters, the better for
Yes.
everybody involved.
Yes.
What is the judiciary doing to address this issue?
Well, at our own end, speaking of the Lagos State Judiciary, we have processes in place when these fellows approach us with such documents. A lot of times we run an open door policy at the HOD level, so they come to us, though the scope is limited now, but it is from going as a take away from this webinar. I would impress it upon the authorities that there's need for us to broaden the scope of the awareness to the general public, to notify them that it is imperative for people to desist from approaching customary courts for grants of probate and letters of registration, because it is doubtful if such courts do have such powers to grant such instruments to beneficiaries.
Okay, thank
So
you.
we need to step up the awareness.
The awareness, yeah. Thank you so much. Now, recently we had an experience with some so-called administrators that visited us, that sent in documentations for transmission.
Yes.
And we discovered in the course of processing these documents that the same administrators for a particular estate were appearing as administrators for a couple of other estates,
Yes.
of different names. Is it the practice? Is it possible for Barrister Aaron to be an administrator in my estate and also be an administrator in your estate and another person's estate? Is it possible for one individual to appear as an administrator in multiple estates?
To the best of my knowledge, there is no law that precludes an individual from appearing as an administrator in multiple estates, provided due process was followed in obtaining the grants of letters of administration or probates. Because you find that sometimes there are certain institutions that could be appointed as trustees or executors to various estates. The law does not preclude them from doing so. The important thing is that the proper that due process was followed in obtaining the grant. I'm not aware of any law that precludes an individual from being made administrator to multiple estates, provided due process was followed.
Okay, thank you so much. Further to that, sir, there is this issue of a family that lived all their lives in Lagos, and the patriarch of the family dies in Lagos. And then letters of administration are thereafter obtained from Kaduna. When you look at the documents, you find that this person's properties are located in Lagos. They are located in Ibadan, but the LA was obtained from Kaduna.
Yes.
Is there any legislation that permits that kind of issuance of letters of administration from another state for assets that are domiciled in some other states?
Well, to my understanding, letters of administration, let us use the example you give now. Somebody obtained letters of administration in respect of assets in Kaduna State. Now the person has assets in Lagos State. Now every state, every probate court in every state is limited by territorial jurisdiction. In other words, the high court in Lagos State cannot issue grant of probate or letters of administration over assets domiciled outside Lagos State.
Wow.
Because of territorial, particularly land. There's something we call the lex situs rule in law. It means the high court of a particular place has jurisdiction in the place where the land is located. So territorially, you cannot grant jurisdiction or rather grant probate over assets that are outside your state. So what happens, and because like I said earlier on, there can be no two letters of administration over an estate. What happens is that where you obtain grants of letters of administration in a state over assets in that state, you can apply to reseal. The essence of resealing is to extend the application of that grant over properties in another state. The law allows for resealing, but you cannot obtain two LAs or two grants of probates over assets scattered in different states. Same with countries. There's a case we are dealing with now where a deceased person, the man had several wives. Okay, now the man had assets outside the country, obtained, and upon his death, one of the wives obtained grant of probate in a foreign jurisdiction, and has now come to Nigeria to apply to receive. That is the process. You cannot come to Nigeria and now say we should grant you another letters of administration. What you do is that you apply for resealing. Resealing means you are applying to extend the application of that earlier to assets granted in Lagos. And not just that, if the man has assets in several states, that's how they will go to each state to apply for resealing.
So, but the primary jurisdiction will be where the person lived.
Not necessarily. Like I said, this particular person had assets in America. He was lived in America, had assets in Nigeria, lived in Nigeria. Okay. Apparently, the person died abroad. And upon the wife fulfilling the conditions of showing that she's the widow and obtaining the grant of probate in the foreign jurisdiction, she could not now come to Nigeria and obtain another grant in Nigeria. All she needs to do, all she could do, which she is trying to do now, is to apply to extend the application of that grant obtained in the foreign jurisdiction to assets in Nigeria. Because that is the position of the law globally. No estate can have two letters of administration anywhere in the world. So the estate is at liberty to apply. The estate is at liberty to apply for letters of administration in any jurisdiction. And once they obtain the letter of administration in one jurisdiction, they can only reseal in another jurisdiction. They cannot apply for another one.
Okay.
It's precluded by law anywhere in the world.
Interestingly, that was going to be my next question, because before this webinar started, I had received a message from someone that saw the flyer online that he was appointed as an executor for a friend's estate. The friend they both live in the United States.
Yes.
And the friend does not have family in the US, and has appointed this my friend as an executor of his estate. So what you are saying now is that eventually the family of the asset owner can apply for resealing of the grant of probate
in Nigeria. Yes.
Not the issuance of a
fresh
new
one.
Yeah.
Yes,
Okay.
yes.
That is clear enough.
Yes.
Thank you so much for the answers that you have provided. I'm sure that our viewers have more clarity on the probate administration process and the issuance of letters of administration in Nigeria. No doubt you have had your questions. We have been able to address some of the questions that you have regarding how you can go about obtaining your letters of administration from the various high courts in Lagos. And also you've learned that it's only the high courts that has jurisdiction over issuance of letters of administration, and not customary courts, nor even magistrate courts.
They don't have jurisdiction.
Even magistrate courts don't have jurisdiction over. Oh, that's quite interesting.
Over probate.
Oh,
they don't
wow.
have jurisdiction.
Wow.
They don't have jurisdiction.
So even magistrate courts do not have jurisdiction over probate. It's only the high court that has jurisdiction over probate. Just on a final note, I recall that there was an instance where we received a couple of probate letters from customary courts, from magistrate courts, if you remember, Barrister Aaron, and we had a hard time going back and forth between a client company of ours who had advised them, who received these documents and sent them to us for processing. They insisted that it was issued by the court, and that we did not have a right to reject it. So is there any way that the registrars can be protected from any liability if there is a fallout, based on these probate letters that have been accepted from any of these lower courts?
Thankfully, your organization has legal departments, and I'm sure the lawyers there are well versed in the law and could advise appropriately. Like I said, the first thing to look at, because a lot of these end users, I don't blame them, they are not versed in issues of jurisdiction. What they do is that I approach the court give me these documents to work with.
Yeah.
It behoves on each court before assuming jurisdiction to issue or purportedly issue probates or letters of administration, to go through the law establishing such a court to find out whether it has the powers to do so or not. Like I said, I'm saying emphatically that it is doubtful in Nigeria or today that customary courts and magistrate courts have jurisdiction over probate matters. Even if perchance you may find that some states may have made legislations that empower customary courts or magistrate courts to so this, but when faced with the constitutional provision that confers unlimited jurisdiction of the high courts, the constitution supersedes.
Wow.
It supersedes. And to that extent, the powers of the high court over probate trumps that of any power of any other court. There are sometimes, and even I understand, you find that sometimes some, even though I've not, like, I'll be mindful of what I say because I have not read the enabling laws setting up some courts like Sharia courts to know. They have not read, so I'll be mindful of making pronouncements. But what I can categorically say in this webinar is that probate matters are exclusively within the jurisdiction of the High Court of States, going by the rules of all these courts, these high courts.
Okay.
Yes.
Thank you so much.
Yes.
Now, on a final note, do you have any parting word for our viewers regarding, the topic of this course? How they can, get seamless service from the probate registry,
What I would advise is, before proceeding to commence the process of or applying for grants of probate or letters of administration, it's important that you seek out competent and experienced persons to assist you in the process so that you don't fall prey to some of these bottlenecks. At our own end, we are doing our bit to address the bottlenecks at our own ends, such as courts and such as the bureaucracy in the court and the probate registry, and the ongoing efforts to automate the registry of courts. But basically, it's imperative that users seek competent professional advice before they start this process, so that they are guided and do not fall into and they don't end up becoming victims of these bottlenecks, which are generally avoidable.
So does that mean that as an individual, I cannot walk to the probate court and undertake to do the process all by myself?
You can do so. I'm not saying you shouldn't do so, but the issue is that, are you familiar with the process? Before you go ahead to even, you can even approach the probate registry. Say, please, I want to obtain letters of administration over this estate. What do I need to do? How do I need to go about this so I don't have issues? When you seek advice and you are given advice, the likelihood of falling prey to some of these bottlenecks is greatly reduced.
Thank you so much. On that note, viewers, we would like to bring this edition of the 5th edition of our webinar, Overcoming Bottlenecks in the Probate and Letters of Administration Process in Nigeria, to an end. We have had a wonderful time with the Chief Magistrate, Mr. Patrick Nwaka, and I'm sure that your questions were adequately addressed and answered. No doubt a lot of us are better enlightened and more knowledgeable about the process now than we were before the webinar commenced. Thank you so much for being a part of today's webinar, and we look forward to seeing you at the next edition of the webinar coming up in a couple of months' time. We look forward to seeing you. God bless you and have a wonderful, wonderful day. A final word from you, sir.
I want to use the opportunity to thank the management and staff of First Registrars Investors Services Limited for giving me this opportunity to share my little knowledge on probate matters before the world. Thank you very much.
And Barrister.
All right, I want to thank First Registrars for giving this platform and also our speaker for taking out the time to come. And I want to use the opportunity to tell everybody that First Registrars can help you in the area of your probate matters. We can help you in the area of obtaining your letter of administration, process your transmission, and ensure that we put swans in your sheet and solve all your probate issues. So you are free. Our service is top notch. You can come to us for your probate services and needs. On that note, I think I say thank you.
Thank you so much. If you would like to engage more with our topic for today, please go to our YouTube channel and any of our social media platforms scrolling on the screen. You can find us on www.forceregistrars Force Registrars and Investor Services .com. You can also find us on Facebook as Force Registrars Nigeria. On Instagram we are Force Registrars Nigeria, and on X we are Force Registrars Nigeria. You can send your emails to us at info@forceregistrarsnigeria.com, and we'll be very happy to answer any question that you may have regarding any of our services. And also, if you have any question regarding this topic, please don't hesitate to send your question to our YouTube channel. We'll be addressing those questions once we get them. Thank you so much for taking our time to be a part of today's webinar. God bless you. Have a wonderful day. Bye.